Start from where we left off. First of all, good afternoon, good morning, where you are actually. Thanks for actually giving me this opportunity to take this session because it's even a learning curve for me as well to talk to different people, get the different perspective based on my experience. So yesterday was a very interactive session, which I actually encourage even today that we have that. So we left off yesterday. I think we started talking about privacy policies, best practices, and we did actually have some conversation on international data transfers, how data security with respect to cloud, private cloud, vendor hosted clouds, and then we talk about hybrid infrastructure. So we did speak on few things which are very elaborative, which are separate topics to be actually debated and also to have a different perspective. But as we evolve in this discussion of data protection, data privacy, I think it's very important that we actually have aligned to our best practices. So what we have is what are the key points to build a strong privacy program in any company. So that's the slide which we are actually talking about. Which yesterday we did touch base on having best practices. What is a kind of like a clear policy on how do you ensure that there is a clear and easy accessible privacy policy which serves as a foundation for strong privacy program outlining a personal information handling practices. So I've actually in the further slides, I've actually put up some thought process on how do we conduct the data privacy impact assessments and with respect to giving the context from Australian perspective. So we'll go through that. The best practices from any of the regulations or any of the auditors would be that we actually have a very clear policy on how we are actually capturing the data and how we are actually storing this personal information and how we are handling that personal information with respect to, as we discussed yesterday, staff training, then what are the different controls and access process we actually put through. So there are few things which we have to do, but there should be a clear mandate. What is this policy? Actually, there should be a clear policy, a clear mandate. That's one of the best practice. I just move further, then communication policy. See, any role, what we take in IT, and many people are from IT who have elaborative experience, and they have actually they all agree and understand that active communication is very important in any role. So especially in these kind of framing of policies, be it security policy, be it privacy policy, be it a data like a policy, data governance framework, because I also work on data governance and data governance framework, setting up data governance framework. Currently, we are actually working inside the company of setting up a data governance framework within CW Retail. So at that point in time, the important aspect, how do you bring the staff into a perspective? How do you communicate clearly the policies, what you laid out? So the policies and procedures are the kind of an agreement which we actually all align as a company into a kind of agreement on how we can actually run this particular framework. So that is clearly communicating those policies which have been formulated by a steering committee or a council. Then how do you actually send this to the stakeholders, be it customers, because they are the actual source of information we are actually storing it. And then how do you actually train your staff in handling this information through various channels, like be it a store channel or a web channel or an omni channel. And then vendors, that's the important thing which I actually missed out, is how do you actually ensure that the customer data, which is also probably in the hands with a vendor, how do they actually handle it? So this is mainly to actually raise awareness and understanding. So to have a clear cut best practice of communicating, setting up a policy is one thing. How do you communicate the policies to various stakeholders is another thing, what we actually have. I'll actually go through the next slide, which is a staff training, which apparently is very, very important. As I actually yesterday, I was telling you that humans are the last firewall for any company. So the important thing when we have a staff handling customer data, handling privacy data, handling personal data, if we need to have a regular privacy training for all staff members, is very crucial, covering key privacy principles and data handling practices and breach response procedures. As we discussed this particular things yesterday, when we actually spoke about how do you handle what is meant by noticeable data breach, and what do you mean by how do you actually handle data with respect to the staff or with respect to any of the stakeholders. So that is very important that the companies do emphasize and spend a certain amount of budget for staff training, making them aware of any kind of training with respect to security, with respect to privacy, with respect to protection. So this is general awareness what every staff should actually like have. So this emphasizes the best practices of staff training. I'll stop here. Do you have any questions till now?
Yeah. Hi, Chetan. Chetan here. You
Yeah.
mentioned about the customer data that is handled by the suppliers or contractors of the
Mhm.
company.
Mhm.
So, how is that then managed? So, does that supplier has to prove that okay they are handling it as per as per the company specifications, and do they have to undergo all the staff trainings, etc., etc.? So, how that is handled?
Yeah. Thank you. Thanks for the question, Chetan, first. See, the important thing is right now we are in this kind of a global world or a global perspective where we do work with different partners and stakeholders, including suppliers. So definitely we use different tools which we might not actually build in-house. So that means we might actually use a SaaS product from a supplier who might be a well-known, say for example, we use Microsoft or AWS or whatever, then we use their partner framework to actually like work with them. So definitely they will actually like handle certain data. So in that particular case, the important thing is we need to start with with specifically what kind of before we actually choose them, what kind of contracts we can actually go with them, and what how they actually like handle their particular data with respect to because data we are the custodians of our own data. So in that particular case, we are responsible and we are accountable for any data which is held by the vendor. So in this case, first we need to understand how the vendors are actually like if we use their software, how the vendors actually handle our data, what kind of protection they actually like have, what kind of controls they actually like can actually make it available for us. That is very important for us to have a policy and a framework. So if we have a policy and framework, definitely we can share that particular framework and policy to the vendors, and vendors have to align with. Then we can actually benchmark the vendors based on whatever we are asking them to do. So basically, it is our requirement, and vendors have to adhere to the requirements. We sometimes you have a situation where vendors would not operate from Australia in our case. So in this case, if they handle from Singapore or the nearest location, say Indonesia or whatever, the vendor is actually located. So then how do they handle that particular customer or PI data? There is no rule which mandates that if Australian customer is actually there, as long as the consent is there, the customer data can be taken out. But then in that particular case, how do they handle the international data transfers if we choose them? So in this particular manner, we always have to continuously evolve that relationship with the vendor, be it giving them a kind of a favor and continuously auditing them initially as a kind of a benchmark, and then continuously doing an audits frequently as much as possible to ensure that they're adhering to this particular framework. Our data is always actually, let's say, then in this particular involvement, we have to do stuff in how we actually train our staff. We need to ensure that if our data processing is actually done at that level, we need to actually like ensure that the controls of the same training is also done by the supplier in that particular in their company to ensure that they adhere to our policies and framework. So in that, to summarize, they have to adhere to our framework, whatever framework we have. That is very important for us to have a policies and procedure document to ensure that vendors actually follow that particular document, and we evolve our framework as we learn from based on our different experiences. Does it answer your question, Chetan?
Yeah, yeah. Thanks, Chaitanya. Just one more last question. But in that case, when we as say my company is going for that ISO 27001 certification, then
Mhm.
does the external auditor also audits the vendors, or
See,
we
if
just say that okay they are compliant with our policies and external auditor is happy with them? Yes, sorry.
no, external auditors usually will not be happy with whatever we say, right? Then what is the purpose of having an external auditor? See,
Mm-hmm.
in this particular manner, definitely we should, if really there is a PI data or a sensitive data which is handled by the vendor and external
Mm-hmm.
audit, and we are actually going for external auditing, definitely the auditor should involve the vendors in that, but unless until you show them a kind of a reliant document from the supplier where they actually agree, this is how, where they document, this is how they actually like store the data, they actually have access controls, they actually train their employees in handling this particular data, and what will happen in case of there is a breach, how do they actually respond? Everything has to be catered. And unless or until that is actually like done, because the partners are to you, not to the external auditors. Auditors look at your whole company, including your stakeholders, as one whole set. So you need to actually like make them aware of what you are actually like doing with respect to your partners, who are your partners, and if they are actually like handling any sensitive data which your company has given the contract to. So definitely external auditors should have that preview within that ISO 27001.
Thank you. Thanks. That answers. Okay.
Chaitanya, my
So
question is, sorry
yeah,
to interrupt.
no,
My
please.
question is pertain to privacy policy. And there is always a confusion whether do I have to maintain the policy in my company website or maintain as a separate document, or does it needs to be reviewed by my legal team? So
Yeah,
how do we
yeah.
have this privacy policy? Do I have to keep it in the website or keep it in my SharePoint, like how we deal with the information security policy internally within the organization?
See, the privacy policy within your website is more towards your external stakeholders, like your customers who are actually the data source. And they, because as a customer, if I want to actually like know how suppose if I go to chemistwarehouse.com.au, our website, and I actually do some shopping, and I actually store some information related to my first name, last name, my date of birth, my address, and my gender, my actually like my credit card information, because I actually do subsequent purchasing. So in this particular manner, so I have every right to actually like to understand where my data is stored, how it is stored, and whether I've been actually consented to actually like store that particular data. So in that manner, the privacy policy dictates that, and also there should be a nomination for your privacy policy to actually like say that in case of anything, any question, how do I reach out to the company as a customer? Is it my customer service info@chemistwarehouse.com.au, or is it someone else who can actually like deal with any kind of privacy question? The first standard point of is customer service. To answer your question, the privacy policy on your website should dictate how the data is actually like mandated and what is the kind of framework we actually like follow to store this data, to handle this data. Whether the data is actually sitting in the location as a customer is actually like there, or is it going somewhere. All this information should be given as a clear mandated policy. Now, with respect to your other question related to, do you have a separate document? 100%, you should actually like have a document which will be a kind of a live document, which will actually give you a perspective, not only from a customer perspective, but also from your internal security team or in an internal stakeholders perspective, and also within your partners perspective, to ensure that we actually like have a document. Now, whether you publish that everything on a website, or you actually like have a kind of a subset on the website and then you actually store a separate document, it is up to the company to company, it can differ. At the same time, legal preview is definitely required, because data privacy, even though it's a prerogative of a data team or a security team, as much as it's actually there, it's also a digital law. So what it means is, a person usually from a data privacy framework perspective, people who actually do law, they extend themselves to understand digital privacy and data privacy, because it's easy for them to understand from a cyber laws perspective. So in this case, ideally, if you have someone in your company as a legal team and they are actually well versed on the data privacy principles, they should be a part of they're part of your team who's responsible for framing up the data privacy like policy within your company.
Perfect. That is pretty much clear. Thank you, Chaitanya.
Hi Chaitanya, this is Bhakta Das. My
Yeah,
question is,
but
how different is Australian privacy policy from European, like GDPR?
see, to be very honest, the way the data what we are talking, whether it's related to health records, to personal records, or your sensitive information, your passport number and all this information, every country originated from the stringent principles of GDPR, right? So in this particular case, specific principles might differ between country to country, but overall the baseline version should be the same. How do you handle the personal data, sensitive data versus health record data? So as we go into the slides, I have an example where specifically what we store with respect to Australia, I will actually like go through. But having said that, the baseline should be the same, whether you actually like have any European country or any country with respect to which can actually have a very stringent data privacy like law. For example, you take India, DPDT, we still the data protection, and so that's a recent 2023 law which was actually like came up, and I was reading about it, but the wordings are different. But when you actually like compare the Australia or India or any of the major countries which are actually like handling, which have a very strong laws principle, it's fundamentally the same. How you handle the personal data. In some countries it's called as data processor, in some countries it's called data fiduciary. So the terms are different, but the meaning is the same. So to answer your question, it is almost they might be ifs and buts here and there, but mostly the information about how you actually handle the data should be the same.
Okay, thank you. And got another question. We have different business verticals, right? Healthcare, retail, banking, or financial institutions. Does this Privacy Act, more stringent towards one domain, maybe less towards another domain? Maybe can you say, like, for financial, banking and financial industry, it should be more strict?
See, if it all depends on what data we are dealing with, right? Yeah, there is a kind of a thing that if it is personal data, how do you define your personal data is very important. So with respect to your question, with respect to LOBs, banking are strict under regulations. Telecom is very strict under regulations. Retail is we don't have a kind of a retail body which actually takes care of the regulations with respect to data privacy and stuff. And similarly, health is very stringent because you're dealing with customer prescriptions. But to ideally your point, the framework should be designed as per how much of data with respect to your customer you are actually storing it, whether it is a personal data, whether it's sensitive data, or is it related to sensitive when I say prescriptions and something. So depending upon that, your framework or a policy should be defined. Say, for example, Chemist Warehouse, we deal with customer sensitive data because we deal with prescriptions. So in this particular case, definitely our involvement should be more deeper because we day in and day out, we handle customer sensitive data. Similarly, if you take, for example, telecom, it depends on what kind of information actually like telecom industry actually like handles versus you have a banking. So all these domains actually deal with if the data is sensitive, termed as sensitive, then definitely the policy should evolve to ensure that the information is actually protected in a manner which is laid out as per the best practices, what we have or what we want to, what we are going to.
Okay, thank you.
Yeah. I'll just move on. So then the final step is regular review. This is very important. So all the questions, what we are actually like talking about or discussion, what we are is related to regular review and update your privacy policy. As I said, human being evolved as we actually go. Even when we joined our IT, say my knowledge evolved as I actually get experience. So similarly, our policies should evolve based on the best practices laid out by a regulatory body, like for example, the Office of Australian Information Commissioner or the respective regulatory bodies. So that means the data privacy practitioners or the team should continuously go and evolve what are the best practices which are actually like happening, what kind of data breaches are happening around the world, and how did the world actually like react, and then they actually like came up with a better update. So then how does that impact our company's policies and procedures, and then it will help us to remain effective and compliant. It is your patch, say for example, your patch management on a server. Say if for example you leave your server which was set up in Windows 2008 and you leave it saying that it is secure because it is on premise. So then we are actually like sitting, the terminology is like you are in like a frog in the well, where you don't really know that there is a lot of things which are happening outside world where your system is becoming unsecure. Similarly, anything what we actually like put up, it will cease to exist. That is a continuous maintenance and support is required. That is where we need to regularly review and update the privacy policies because the world is changing. Definitely the laws will change, and definitely based on the laws, our privacy policies will change. So we have to evolve. That's the main purpose of regular reviews. And also, this is very important that we need to have a dedicated team, whether it's internal or external auditing. That's different. It doesn't mind, but we need to have that regular review to ensure that we actually are on alignment with the policies to remain effective. So that is very important because this is related to law of the land. So this is related. Now, if I move on, individual rights, I think we briefly touched as well. So with respect to how do we address individual rights and requests related to personal information handling? So we have been discussing this. It's not a new subject since yesterday. So the important thing is how do you access the request? So individuals can request access to the personal information, seek corrections if required. So if I'm a customer, I think to one of the point of what Chetan initially agreed on, or we discussed on, is the privacy law policy within the website. So that policy should state if you're a customer and you actually and we store your information. First of all, I should know how you're storing my information, where you're storing this information. At the same time, if my surname changes because I want to because I got married now, I have to change my surname, or I have to change my address, I have to change my phone number, whatever it is. I should be able to actually request access what information is there, and I can actually see correction. Either I can actually do it myself, or actually I should be able to get to my customer service and actually able to change it. So that kind of opportunity now every website is actually giving, but this is a kind of a fundamental right where your access request it should not be denied. So if whatever you actually store should be able to edit, and you should be able to update, and you can see corrections if needed. That is the main purpose of this access request with respect to individual. Then handling complaints. So this is very important. The businesses, any businesses, with respect to any other, we should have efficient process to address customer concerns, like setting up a dedicated call center, and also when we receive a complaint regarding personal information handling, how do you actually handle it? And in case of a data breach response plan, how do you ensure that you continuously update customers who are in a panicky situation? Especially in Australia, recently we do had a lot of data breaches, with respect to telecom, Optus. Then we actually had with the insurance company, Optus actually had a second where they actually the network went off recently. So in this particular case, how do you communicate this back to the customer at the same time when customer calls you? How do you handle those complaints? So it's very important that to keep the customer's concerns actually paramount, and then ensure that we address their complaints regarding personal information handling, because there's obviously a conscious effort we need to put there to ensure that the data or the concerns of the customer is actually addressed. So that is the kind of handling complaints. Then you have opt-out mechanisms, and many of you, everyone have gone through this. You can always unsubscribe to mailing list, or you really don't want to actually be bothered, and you should have a mechanism to be opting out mechanism. At the same time, any consent what you give should be minimal. That means the website should not actually force you, or any company should not force you to check all the boxes with respect to the consent. It should actually give you an opportunity to say accept all, or you can actually only accept what you actually need. So you have that opportunity to review, and if you are not comfortable with that, you can always have that mechanism to opt out in that particular. So you have, that is a right where you can opt out from a direct marketing communication. Say, for example, Chemist Warehouse does catalogs. Catalogs are promotions we can send to all customers. But if I choose not to get bombarded with these direct communications, even though it will benefit me to get the best prices from at a cheaper rate, no, that's if I'm not comfortable, I should have that right to opt out. And then so that it should be clear and prompt opt-out option. That means I should have a clear mechanism where I can clearly go to the website, and there should be a clear way to actually go and opt out or unsubscribe from that particular mailing list or any kind of promotion activity. So that should be clearly mandated. Then you have maintenance preferences. So it is very important to keep an accurate and up-to-date customer preferences records to comply with the regulations and build trust. So customer preference on consent, or customer preferences on how they want you to handle their data. So all these things have to be recorded. So that's the reason nowadays, if you see, there's consent management system separately. There's a consent management systems which actually take care of it. Then I was working with Auditor, which is one of the customer identity platform. So they have a consent management system, and every customer can actually choose their own login to log into our websites. And then you can actually have a single identity to identify a customer, because customer can log in through multiple email IDs. They can create multiple profiles. They can we have a duplicate data. Then it becomes very hard to maintain preferences. So that is the reason having a customer identity platform like Auth0 or Okta now, which is acquired by Okta, or Azure B2C, or any other equivalent identity platforms, to ensure that we actually can actually have a kind of a unique identification for the customer. It is also provide security, so ensures that we can store the information about the customer, and they do an up-to-date information of the customer preference record. That means customer updates at one place, it is actually cascaded to multiple areas wherever the customer is actually doing whichever channel the customer is coming into the company. So this is very important to have this kind of information so that we can actually address the customer concerns better. It is easy for customer service when a customer calls to identify a customer and to actually update the customer preferences in case if the customer chooses to update, then it's easy so that it can cascade to multiple systems across the company. So wherever the systems actually handle customer data. So we need to have, that is the reason customer data domain becomes a very important domain, at least for retail or the people who are handling customer data, telecom, banking, all these domains are critical because they day in and day out deal with customers. So that is the reason, and especially retail, the experience of the customer or the lifespan of a customer is very less. That means if I have a very bad experience at a store for one instance, I definitely will have an option to go away from the store. That means the store is losing business. So it's very important for us to ensure that we take care of the customer experience. At the same time, it's not always about generating revenue. It's about ensuring the customer preferences are actually taken care, especially from a data perspective, because customer doesn't really understand this particular aspect. So we should be really careful on how we are actually handling this data and how we can actually purge this data if customer chooses not to have the data sitting with us. So there's different ways to actually do it, and then now they have different platforms across the companies, across in the market where we can actually maintain. And there are different customer data platforms. So Dynamics 365 Customer Insights actually is one of the things. Then we have Miro. Then we have mParticles. There's a lot of customer data platforms which around the world they're actually having market leaders who know how to handle customer data. Any questions? All right. Yeah, please go ahead.
So, whose responsibility in the organization is to maintain all this data, like customer data, this consent system, etc., etc.? Is
See,
it
it is
CEO's responsibility or is it someone else's?
No, actually, see, privacy by design should be part of company's responsibility. It's a good question, actually, because there is no one team which can actually manage it. But at the same time, there should be someone to actually audit that particular thing, whether we are aligning to whatever the best practices which are being laid out by as per the framework. So in this particular case, what we do is we put requirements of privacy and security as paramount as a part of our design itself. So in this case, any project which actually deals with customer data, it goes the security and the private security is because privacy is a part of security team. We actually ensure that all the requirements on security and privacy are actually taken care. So that's what we call it as privacy by design. And then we need to ensure that is it aligned to the framework what we have. And if the framework has to be updated to actually deal with the requirements, then we'll actually work with it. So that means every project what we actually take is actually going through these particular checks from the design stage itself, or the architecture stage itself, or the requirement stage itself. So in this particular case, to your question, whose responsibility it is the responsibility of the company to ensure that we actually follow the security first, privacy first design principle. So in a way that a company is taking paramount priority towards the moving towards the design principle what I just said. So it is a company's responsibility to ensure that they understand privacy, they understand how they actually need to any kind of implementation they do projects related to customer data or PI data or sensitive data. They have to have mandated this particular requirement framework. And we take the example of our company. Right now, I will personally review some of the projects where we deal with customer data, and we do ensure that we actually align even with the app principles. So we say if this requirement has to go with app one, which talks about transparency of the customer data, we do mandate that particular project to actually go through this principle and to prove that during testing that this particular whatever the requirement they are actually fulfilling is actually aligned to the app principles what we have for Australia. So that is the level of detail we are actually now going. So to your point, we do have a dedicated team, but not every company can have a dedicated team. So it is actually up to the project teams to actually do it. Some do it post, some do it pre, but I would recommend that we should do it from design perspective. So there is no specific thing on it depends on how company is actually dealing with the privacy of the data. If the company is dealing with any data related to private, related to sensitive data or personal data of a customer, definitely they have to follow the best practices. And my recommendation, again, everyone don't follow the same recommendation. is to make it privacy by design. What it means is that whatever project you do as a part of your requirement gathering, how you actually capture your functional requirements, how you capture your non-functional requirements, privacy should be part of your non-functional requirements.
Yeah, understand. So that's part of the project. I understand that part now. But then when it comes to the maintenance, for example, there might be some fix done, like that project work has done there, the privacy, implemented the privacy framework, all done, very good, audited, well done.
Yeah.
But then during some of the maintenance activities, some fixes somewhere, that privacy might get broken up and nobody notices that. So my question was related to the who is the owner of such things? Is it the DPO? Is it the CISO? Is it the who? Because
So, yeah.
if there is a data breach and that data is stolen, so either it's a security fault or it's the system fault or that application fault, right? So who is
it's a good question.
who is owner?
So it's a I'll tell you honestly, it's a very loaded question. The reason being, if you need to have very strong IT change management process. What it means is any change what we do, we'll go through a change management. Change management actually has to have this particular reason. See, again, I'll go back to my company. We have every change what we have, we'll go through CAP, right? The change approval board. In this particular thing, we have right now in our company, for example, we don't have a DPO, right? What is data protection officer? So it is a shared responsibility of a cybersecurity and data team in our case. So we work with our cyber team, and then we are part of the CAP meeting. So in this case, any change which actually goes through customer, any system goes dealing with customer data, even you do a label change, we do actually recommend, we do actually insist that they actually will go through CAP meeting. So that means no change can actually happen unless until they go through CAP meetings, especially for the systems which deal with customer data. In this case, all the things which actually go, even I'm just highlighting that it's a label change or anything which is not even a kind of a change which will not impact anything. We do insist that it actually goes through it, and then we ask all the questions. Only if the satisfaction is there, we will actually mandate that change to happen. So anything to answer your question specifically, if you are dealing with customer data, any system which is dealing with customer data, that's where your staff training actually comes in, is how well your staff is educated that if you are dealing with these systems, dealing with customer data, how you are ensuring that you actually the impact, you understand the impacts, you raise a change, and then you actually go through the CAP, come and actually tell the CAP what changes have been made, and you convince the CAP.
I'm not able to hear Chaitanya. Is that problem?
Yeah. I also lost him.
Okay.
Yeah. Let me text him actually. Just give me a second.
Yeah.
You are back now.
Yeah. Sorry,
You're
actually,
talking about the CAP. You are talking about the CAP, and there we lost you.
Yes. So what I was actually telling you is the just I'll present once so that you can. Yeah, I think I'm here. Okay, so with respect to CAP, so to Anand, I think is it Anand or he was asking this question, right?
Chetan Patil.
We again lost him.
Yeah.
Okay, cool. So what I was actually telling is the importance of the CAP meetings, and how do you actually handle these kind of changes with respect to systems which actually have sensitive or personal information, right? It's a very layered question. The answer is layered. It is not like one software, one team will be there to actually manage it, because you really don't know. In our company, we have 300 IT, it's a very big team of IT. And we have 300 people working in Australia, in offshore, in Philippines, India, and China. and you have like different we work in very global structure. So in this particular thing, we can't actually really have one team going and understanding all the changes. So in this case, everything should actually come through CAP. So that is a very important aspect of how do you ensure that you set up your other process right, because if you start working from an IT perspective, everything is actually related. That is, privacy should not be treated as something which is unique.
Yeah.
Our security, privacy, and the kind of changes what we make into our system, it is all responsible equally. Everyone is responsible to what they do. So, but especially to your point, any systems which handle the personal data, customer data, or anything related to sensitive data, we do have a very kind of a layered, stringent way of like accepting the changes. And if those changes are not, we are not convinced with what they are doing, we won't allow that to actually like happen. So everyone has to follow through the CAP principles, especially in my experience of what we actually like have. And I do know some companies, they actually like have a different way to do things. Now, is it the right way to do it? No, definitely it's not the right way to do it. But is it the way they have to do it? See, no one questions you if you don't follow the best practices. But you don't want to go into a situation where you actually go in front of OIC, which is the Office of Information Commissioner, to actually discuss about data breach response plan. We want to avoid that, and we want to ensure that we respect the customer's privacy. Otherwise, you are actually losing the customer, because within 2 minutes you can lose a customer. The reputation of the company, what we built for 30, 40 years, is actually lost in 10 minutes. So that is the main purpose, that we should be very careful. The teams who are responsible, equally every person in the company, especially in IT, they are responsible for what they do. So that's the reason the important thing is emphasis is on training. So this is all layered. Everything should come together to ensure that we actually do things right. So in this particular thing, definitely if the company can afford to have a dedicated team for data privacy, in our company, we don't have a dedicated team because it's as I told you, it's a collaborative effort of data and cybersecurity. Sometimes we do involve our legal team, but our legal team is only proficient in Australian laws. If we are actually dealing with different laws of different countries, definitely we have to take a local expert's help. But we do have a collaborative team to actually like look into this kind of situations.
Thanks.
Yeah, and my apologies that all of a sudden, can you, Subbu, can you make me the host again?
Yeah.
I don't know why actually like all of a sudden Zoom did not like me, guys, and so my apologies that I'm actually like
Man in the middle attack. Huh?
probably the man of the middle attack, and thank God that someone did not speak on behalf of me. So at least in that way, I don't think it was a man in the middle attack.
The man in the middle of the meeting attack, actually. No. Okay.
All right. So now we'll quickly talk about the regulatory body of Australia, OISC, which is the Australian Office of Australian Information Commissioner's role. So as I told you yesterday, the OAIC is responsible for enforcing privacy laws and protecting personal information. So they are the regulatory body in Australia who are actually like putting up the best practices, who actually like work with us on the noticeable data breach plans, and also like setting up the app principles. Now they're also working on revising this particular app principle. So in a way, they actually are the like kind of a SEBI or a RBI in India for banking. And I'm not sure. In India, they are putting up a data protection law board. I think soon that law board will be formulated. They did not decide which city this board will sit, but there'll be a legal body which they'll actually like put it. So it will be working directly with the Indian Government Information Broadcasting Ministry. It sits under that. So I've just read it. So it is similar to equivalent of OIC. They are actually putting up something, that data protection law board. So that will come soon, what I understand. So then they are also responsible for penalties. Non-compliant businesses may face financial penalties, legal costs, and reputational damage, which apparently is a paramount. That is what a company should be like discouraged. That kind of motivation companies should actually like have to ensure that they follow the best practices. Then recent cases. So it's very important for every company. Like I think what Subbu does, for example, posting LinkedIn, the data breaches, what actually like all over the world, what the companies actually go through. How do we examine it? How do we learn from it? What are the insights we actually get out of it? the consequence of data breaches, and then how do we actually train ourselves and prepare ourselves and involve ourselves. So that is very important with respect to the recent cases. These are the main things of role of AIC is to actually like understand that, to actually go through the recent cases across the world, try to understand, evolve that particular policies, ensure that they actually conduct trainings for the companies. And again, these are not mandatory trainings. These are the trainings in the website. Any companies can actually go, or any individuals in the companies can actually go and understand what is data privacy, how does Australia actually like deal with data privacy. This is an excellent website, and everyone can actually go there and actually like learn. And then you do have like enforcement action. So in case of any data breach, what are the enforceable undertakings and civil penalty proceedings demonstrate OIC commitments to compliance? So this regulatory body is not just a recommending body, it is an enforcing agency. What it means is that what if you don't follow the best practices, what we actually have, it 100%, it will definitely have, it will surely actually like ensure that you actually like undertakings on the civil penalty proceedings, that you can actually like issue legal proceedings against the company. So this the federal government in Australia mandated this particular OIC to even incorporated cases against the companies which don't follow the data privacy principles, what are mandated by OIC.
So question,
Any
so
questions?
Chaitanya, Bhaktadas here. So how does OIC knows that this company is not following? Is it after a breach, or are there some surprise audits? How do they know that?
No, as of now, it is reactive. So it is more about company actually, like if there's a data breach, they'll put up a remedial plan. They'll understand what is the magnitude of the impact. They'll do an impact assessment of the magnitude of that particular breach. Then they'll put up. They'll actually like issue. Then they'll set up an action plan. It can be fining them, or it can be just sometimes it's just fining them. Sometimes it actually says that no, you have to come to court, because say for example, Optus, which is in public domain now. Optus actually like in 2 years, 3 years ago, they went for a data breach, a big data breach, because of one rogue API, which actually exposed the customer data. So in this particular thing, OIC got involved. They actually were very stringent. They put up a like huge penalty. At the same time, there's a huge case actually like was formulated. This resulted in Optus CEO resigning. Their cybersecurity officer resigning. So there's a lot of penalties which will be enforced. As of now, it's more reactive. I don't see that they are actually conducting any frequent audits, but at the same time, they do recommend that they don't have a team to come and actually like work with us from a proactive perspective, but they do recommend that they actually like work with external auditors or internal auditing with respect to the company. But they will get involved once if there is a data breach.
Okay, thank you.
I'll just move on. With respect to privacy management best practices, this is what with respect to this is important, that the key practices of achieving effective privacy management in any businesses. Conducting PIs, which are the privacy impact assessments, is crucial for identifying and mitigating risk. So what is, if you see, I've just put a text, and my apologies that it is very texty or very so, but I just want to actually like say is that what is the DPI structure or data privacy impact assessment structure? Just keeping Australia in focus, I've just like listed down based on the APP principles what we actually like have. Say for example, as per the Australian Privacy Act 1998, and we have APPs. Yesterday we discussed that any company which actually handles or which actually aligns to the APP is called an APP entity. And so we have 13 principles. As I said, if you see here, description of processing, say for example, open and transparent. So clearly explain how you inform the customer that about the data collection and use, privacy notices, website install. This is what one of the questions which we discussed earlier. So in your impact assessments, as we actually like do it, this has to be done as frequently as you can. It not be monthly. It can be quarterly. It can be half yearly. It can be yearly. It depends on the company's like how much of data you are actually like handling, and then how do you actually like handle how do you collect this data? What do you do with the collection of data? Is it only sensitive data is actually like involved, or is it only personal data what you actually like have? Then what is the notification? How do you notify if you are collecting from a third party? I think this is also once we actually discussed is if a partner is actually like handling, and how do you actually like ensure that there's emphasize the transparency to the customer that we are dealing with a third party and this is a third party information. So it is very important that we actually like notify. So this DPIA or the impact assessment, what we actually like do, should actually clearly notify, should align to your app principles. That is my main intention to put this particular thing. And also like what kind of necessity and proportionality, what it means is it reasonable and necessary to collect this data for your business function? Like, for example, why do you store prescriptions? Why is it a mandate? Yes, it's a mandate from Australian pharmacy that we do collect prescription data. And so in this particular case, we need to tell the customer why we are collecting this prescription data. What is meant by script on file? So how do you send like, because the customers actually like, we do actually like have to store that customer data, sorry, the prescription data for X amount of years. Similarly, we need to store payment data for certain time. So there is a law which actually like does it. At the same time, sometimes we do collect information for something for any other purpose. We need to specify that. And then is it really, how do you store this information? How secure is your storage? And how do you send like security measures to meet this principle? So we discussed all this in a kind of an elaborated manner, but it just mitigates what kind of content will actually go into your privacy impact assessment. So that's the main intention. How do you ensure that what are the measures and as an organization you actually have? Again, this goes beyond data privacy, like your cyber security, laws, what kind of encryption you have, what kind of how do you actually like ensure that you have the right people accessing the right information? How do you really actually like have access control? Do you have customer identity? Do you have an employee identity? How do you protect your devices? What is your endpoint security? What is your how do you actually like do patch management? How regularly you do your patch management on the servers where you actually store your customer data? How frequently you actually like ensure your databases are actually like updated? And how frequently you actually like ensure that you take care of your you run penetration testing? How frequently you actually like do any kind of API testing? So all these things is related. So here it is a very layered conversation what we are actually like having. So everything should actually like align to each other to ensure that we store whatever we store, the sensitive information or the like overseas transfer we spoke about. You spoke about My Health records, which is a prescription records, which in Australia it is called as My Health records, whatever we actually like store. And how do you actually have a customer opt-out mechanisms? What is like, and then how do you adhere to the NDBs, which are noticeable data breach schemes, and how do you plan if really there is a breach? Actually, we discussed about that yesterday. And what is the role of OIIC? And now, see, we discussed what is a guide to DPIS, because OIIC actually is a regulatory enforcement body, but it can actually like provide some guidance, mentorship, and then what is the privacy management framework guide? So they do have a privacy guide for broader privacy privacy policy, which we can take, customize according to our company, what we can actually like do. And then there is a website, if you people have privacy.org.au, which actually talks about your sector specific guidance. One of the honored respected member actually asked me this question. How do you actually like have privacy across LOB? So you actually like it based on your sector, you can actually go there and you can actually see what kind of privacy you can actually like have. So again, this is all mandated through a proper Australian privacy practitioner or a legal consultant. So you need to actually like ensure that you actually work with the related experts in this area to ensure that you actually have the right guidance and right review panel. So, any question?
No, Murthy, just Subbu here. A reminder, okay, we have 8 more minutes.
Yes,
Okay,
yes.
thank you.
So I think, yeah, we'll just quickly skim through. I think mostly we actually like captured minimizing data collection. I think that's what we discussed about this. It's most like implementing privacy by design. I spoke about how do you implement privacy by design. That means you start with your projects from a design architecture of systems, processes, and also like how do you do proactive privacy management. So that's implementing privacy by design. How do you engage with privacy professionals? This is also I've discussed about how do you engage, whether it's a legal counsel, how do you get their valuable expertise, whether it's internal or external. This is a very complex landscape as we're discussing. So we should ensure that we actually have a proper expert team to work with on a privacy, because it's easy to understand, but at the same time to implement that, it is a very layered approach. Companies should actually like everyone in the company should understand this, especially the people in IT. And then this is the key. This slide gives you an overall picture of what exactly we are talking about from Australia perspective. If you see the scope, the APPs, what I've just laid down, the 13 APP principles, which is Australian privacy, and who are the players. individual like me and you. Then you have APP entities, a company, and then the regulatory body, which is Office of Australian Information Commissioner. Then what is the responsibilities of the companies, data protection, having a role recommended of a data protection officer, or the continuously training employees and the stakeholders. Then security governance program with respect to data governance programs. Then you actually like have what are we spoke about individual rights, right to notification, right to access, right to consent, right to object to marketing, direct marketing, right to correction of data. We spoke about international data transfers. We spoke about what is the definition of a sensitive information with respect to your sexual orientation, your criminal records, your health records, and your anything, your political views. So anything which is related to you, it is sensitive information, and what religion you belong to. Everything is sensitive. You can't actually really. And then how companies lawfully practice this processing with respect to app entities. So then again, it comes to your individual consents, like all these things we have actually discussed. I've just summarized this in one slide. Then how do you take consent? Consent must be informed, not voluntary. So at the same time, and what happens if a company goes through breach? What is a data breach notification? What we actually have, and then what is enforcement by OIIC? And we spoke about the fines. We spoke about suspensions and closure of data processing activities. We spoke about legal lawsuits. So all these things are related to, this is an overall view of Australian privacy laws or the design. It actually gives you an overall picture of the lay of land for Australian Privacy Act. I think then I've just taken a quick example where in 2018, one specific company went through a breach. So in this case, they exposed 1.2 million customer records. Then you have investigation findings. What did the regulatory body, Information Commissioner actually did? They found non-compliance and privacy laws. Here again, they have actually, it's a post thing. Then what did they do? They actually ordered to engage an expert for information security to provide first to mitigate that particular risk, and then there's a huge reputation damage when for the company lost potential customer trust. They actually their share prices actually dropped. There was a media scrutiny, and there was a customer backlash post breach announcement. So there's a huge reputational damage. Then what are the best practices the company actually followed? Now they started taking data security as a priority. This applies to all companies, not in retail only. Then we need to have robust system. Again, that's the reason I said it's a layered thing. They need to have very robust system for detecting and responding to your data breaches. So that means you need to have your SIEMs, your security, like the security incident and event monitoring tools. You need to have endpoint monitoring tools. There's a lot of things you have to be actually attaching to it. It is not a foolproof once-off thing. We need to evolve it. Then we need to have a very transparent policies to ensure that the personal information is actually understood by the stakeholders, how we handle it. And then finally, you need to have your privacy awareness culture. As a company, you need to ensure that you are security aware. You are actually ensure that you are data aware. You ensure that you are privacy aware. So everything is actually, again, as I said, it is all related, where we need to engage the employees as a whole to ensure that we invest in staff training. We invest to promote the culture of privacy. We promote the culture of security. We promote the culture of what is the data, where is the data going, how the data is being stored. So in a way that we are actually compliant. So we need to make it very simple for the employee to understand, because not everyone understands this particular thing, because it's very detailed and also sometimes it's very layered. So that's it from my side. If any questions are there, I'm welcome. But 2 minutes from you, Subbu. So, but thank you for this opportunity. I really appreciate your questions and also giving me time. Thank you.
The pleasure is all ours. In fact, we requested you for a single day presentation, but it had become 2 days because of the interaction with the participants. So, in fact, we are privileged to have you amongst us to share all your experiences. Good questioning session from Bhakta, Chetan, Kiran, etc. In fact, the questions are something that that's supposed to dig deeper and get the insights out, right? So, thank you very much. Any questions from anybody?
So fine, so
Okay. So we have our CDPO session starting at 11:30. So I think I will end the session now. I will again the recordings I will upload to the YouTube I'll share the link with you all. Okay, so that you can view it as and when you actually need it. Thank you, Murthy, again. So, anything from your side for us, Murthy?
I think no, thank you for this opportunity, and I really appreciate it. And also, it's a learning curve, huge learning curve for me as well, because as we interact, we learn, we prepare, we actually come and we actually like have a lot of things which. And just to actually tell you, this is not a kind of a. It's a like the questions what we just discussed. It's a kind of a collaborative effort from different teams in IT to actually like ensure. From with respect to, I think Yogesh had a question on CISO or DPO who is responsible for data breach. Ultimately, data breach, if the company can afford to have a DPO, definitely data breach, the DPO should be responsible for it. But at the same time, if the company doesn't have, because CISO is ultimately responsible for the cybersecurity and the data governance frameworks. So, so ideally, it depends on the company to company. In our company, CISO is ultimately responsible. So he actually like goes in. Our CISO is very, very experienced in legal setups. So he set up data governance and cybersecurity and data protection frameworks across different companies in Australia. He's also a part of the Office of Australian Information Commissioner panel as well as a review panel. So in a way, CISO is responsible in our company, but in other companies, it might be the DPO. Like say Tesco actually have a dedicated DPO. So that should answer your question. Yeah.
Thank
you.
Chaitanya, one last question. Moment here. Right. So do you have, as part of, as you explained holistically, as part of the design, the data security, the privacy aspects are being considered. Do you have a fixed shelf life of the data? Because the longer the time that you store the data, you have to take care of it, right? So do you have any design principle that's considered for the shelf life?
Yeah, thanks, Mohan. Yes, we do have. So for pharmacy data, as per the law, we store 7 years. And then for financial records, we store for 3 years. And for customer data, we actually follow the data minimization principle. That means we store as much minimal, as much actually like, so we usually don't store unless or until we actually like have that information to be actually like, we don't do any personalization on customer data. So it's a kind of a layered approach what we follow. Anything related to customer prescriptions, we do have to store for 7 years. Anything related to finance related, accounts payable, accounts receivable, payments, we store it for 3 years. But even though the law says that it's recommended for 7 years, of late we spoke to one of the law experts in Australia. So they said like it's 3 years is enough. So we actually like store for 3 years. Anything else related to customers, which is not related to prescriptions, which is not related to that we have to store, we only follow the data minimization principle. That means we store as much as less period as possible. That period depends on, like we don't have a definition of that, but we do actually like we follow the data minimization principle right now.
Thank you. Enjoyed the session. Thank you.
All good. Thank you so much again, Subbu, and I'll talk to you again.
Pleasure is all mine, Murthy.